Hi everyone, Armine here. I thought this month it might be fun to talk about digital currency and digital assets in general. So a lot of you are probably investing in Dogecoin and Bitcoin and other types of cryptocurrency. So I thought it would be a really good idea to understand what your rights are and what needs to be done in order to protect and transfer that wealth that you're acquiring to somebody close to you in case something happens to you and you pass away. So in 2016, California implemented a new law called the Revised Uniform Fiduciary Access to Digital Assets, which basically in a nutshell means a law that addresses what happens with your digital assets in California if you're a resident and you pass away here. So I want to go through it step by step and tell you guys what the law is going to do and how they're going to treat your digital assets if something happens to you. So at the the way the law is structured is in a 3-tiered system. Which basically means that at the very first top tier, or the first tier, the servicer, and in this case the servicer could be Coinbase, it can be PayPal, it can be any online company that is servicing your digital assets. So at that very first tier, the servicer is going to look to see if you have enabled an online user tool. Now, an online user tool by definition is some sort of tool that servicer has implemented on their website or on their platform that allows you to tell them what you want done. So for example, Google has Inactive Account Manager. Google's Inactive Account Manager, if you enable that Inactive Account Manager, it allows you to let Google know what to do with your Google Gmail account, your files, your Picasa account, your YouTube account, whatever it is that's linked to Google. And you can let Google know, like, hey, if I'm inactive for 6 months, send a text message to so-and-so, and if they tell you I've passed away, I want you to take all of my assets and I want you to distribute it to my mom. So at that very first level, the servicer is going to look to see if you've implemented an online tool that they have available. Now, a lot of servicers don't really have an online tool available, which means that the second tier will apply to most people. At that second tier, the servicer is going to ask your family members that call them up or email them and say, hey, so-and-so passed away and we know that they had Bitcoin with your company, held in your company, how can we have access to it? The first question that they're going to ask is, did the person have a will or a trust? We need some sort of instruction in their estate plan. And if they didn't have any instructions regarding their digital assets in their estate plan, then we want you to go out and get a court order, and we need a court order in order to release this amount to you or transfer it to the new person's name. So at that second tier, the service provider is actually going to ask for some legal documents, some estate planning documents. And if you have a basic estate plan that doesn't incorporate any digital asset planning, then it's not going to cut it. They're going to want to see specific language in your estate plan that addresses digital assets and digital accounts. They're going to want to see that you've named a digital trustee or a digital executor. If you don't have any of that in your estate plan, they're going to want a court order from a judge that gives them permission to release. If you don't have any of that and for whatever reason the servicer has already an agreement in place, and this obviously applies to, this third tier applies to non-monetary value assets, so things that don't have money value but rather have some sort of important sentimental or informational value to your family member, like your picture files or whatever it is. It doesn't have value, so we can't really go to court, right? We can't go to probate court and ask a judge to create an order, but it does have value enough in the sense that your family wants access to it. So for those types of assets, the third tier would apply, which means that the service provider will look at their contract to see what you had agreed to. So if you remember, anytime that you go online and you sign up with a username and password to whatever website or whatever platform, you check a box that says, I agree to the terms of use. In that terms of use, you usually don't know what you're agreeing to, and you can't negotiate it even if you didn't like what you read. But if you open it up, it will have a slew of things that you are agreeing to. And one of those provisions is going to be related to your death. What are you wanting them to do if you have passed away? For example, Yahoo is pretty strict with their terms of service. If you notify a Yahoo if you notify Yahoo that one of their users has passed away, they will actually delete your account with them. They want to protect your privacy as the user, so they don't want to transfer information to anyone else unless there's a court order. So at that third tier, they will look to their contract and say, you know what, we already agreed when this person was alive that we had to delete the account, and they check the box, so that's what we're gonna do. So that's how it works in California. It's kind of a 3-tier system that we have for the Uniform Code, and it might be different in other states. Some states are so far behind in legislating for digital assets that they don't really have a law, which is what we had before 2016 in California. But if you are someone that is investing in Dogecoin or Bitcoin, or you're someone that has an online presence, if your Instagram account has value to your family after you're gone, if you have, enough online presence, now that could be monetary, or it could just be sentimental and informational value for some of these accounts, and you would like to pass it on to your family members, you have to make sure that you incorporate digital estate plan in your standard estate plan. So feel free to call our office. We'd be happy to help you with this. Have a good one.